Aaron.
Yeah.
Why didn't you say it the first time I said Aaron?
Because it's pronounced Aaron.
You done messed up, Aaron.
Aaron is here. Welcome back, everyone, for more SPTV, where every day is one step closer to the total collapse of Scientology. I'm joined today by my lawyer friend, Zach. How you doing, Zach?
I'm good. Thanks for having me back, and welcome, everybody. Glad you're here.
My pleasure. I hear at least one little munchkin in the background.
Yes, little Munchkin ran out of water, so Munchkin's getting a refill. He'll be fine.
Awesome. For any newcomers here, let me just show everyone you can find Zach on YouTube at your lawyer friend Zach. And we are here to talk about someone who done messed up, mainly the Courthouse News Service in this ridiculous article they wrote yesterday with a headline, Judge Guts Leah Remini's harassment lawsuit against the Church of Scientology. Why don't you tell everyone what you just told me about your thoughts about how a publication like this could have such a weirdly slanted headline and article?
So they actually wrote this article after they wrote this article before they wrote the headline. That's pretty common. And some editor or some junior intern somewhere was tasked with, hey, write an eye-catching headline for this. So they scrolled through there. They found a quote, which you can see italicized underneath the boldface. A Scientology spokesperson calls the ruling, quote, a resounding victory. No. They found that, and then they built a headline around it. And so you see Judge Guts, you see a famous person, you see a famous organization, and now we're talking about a lawsuit. And that's how you get likes and subscribes and clicks and people to pay for the paywall to get to the article.
Right. And it's funny because this article is not even behind a paywall, and I don't even see any ads on it, which is why it's confusing as heck to me. And they even made public the filing, which is a little unusual for in my experience on these lawsuits, because these filings do cost money. I mean, when I buy them, I make them public, but that's because my videos already make money. There's no reason for me to hold on to it. Okay, now, when I went through this article yesterday, the truth is the meat and potatoes of this article is pretty black and white, balls and strikes, nothing crazy about it other than, I don't know, the quote from Scientology, which not a big deal.
Sure.
Last night.
Well, and
go ahead.
I want to make sure that this is very clear. This lawsuit is very much alive and well. This is a very healthy lawsuit. Contrary to that headline, this is very much a healthy lawsuit. And as much as Scientology wants to scream from the hilltops like the Sound of Music, look at all the good things that have happened to us, Leah Remini is still in a position of leverage on this entire lawsuit thing. So contrary to the headline, this is very much an ongoing life cycle, and we're still very early on in the litigation.
Okay, good. Without going through all of this, it is 37 pages, and I did actually go through the majority of it last night. Did you happen to see that video?
Of course I did. Why? I'm not going to miss an Asmithlevin video.
Okay, so a few questions that I would have for you on this. The anti-SLAPP motion that Scientology filed and the related attorney's fees consequence for whether it's considered Scientology won or lost. What is your opinion on, legally speaking,
Sure,
how much Scientology won, how much Scientology lost? Are they entitled to attorney's fees? Is Leah entitled to attorney's fees?
Sure.
How does this go?
So I will say this. I think Judge Randolph Hammock, what a great name for a judge, by the way. When I hear Randolph Hammock, like I think, sort of, judicial. That's sort of a judge name. So kudos to his parents. I think he hit it on the head with the language when he says the parties may request attorney's fees, not they have the right to get them, but they have the right to ask for them. They also have the right to ask for the courtroom lights to be green during the jury trial. It doesn't mean it's going to happen, but they certainly have the right to ask for the relief. And the judge was just simply saying this order does preserves your right to ask for relief, but you're still going to have to prove that the law says you get it, because in the United States, all jurisdictions, to my knowledge, have adopted what's called the American rule, which is no matter who wins or loses, each party has to pay their own attorneys. The British rule or the European rule says the winner gets all. The winner, not only do I get my money, you also have to pay my attorneys. But in America, we use the American rule. This is what we call a fee shifting provision. But I don't, because in the way I interpret, and I'm not licensed in California, but the way I interpret the California anti-SLAPP fee shifting provision, you got to get all of it. You got to win the whole thing or you don't get attorney's fees. And last night, I think you asked a fair question, which is how in the world could you possibly prorate this? because if they won 60% and they lost 40%, but maybe 80% of their time was tied up in the 40% they didn't win, like how do you prorate that? And so as I interpret the California anti-SLAPP fee shifting provision, you have to win the whole thing or you don't get any of your fees. But I think the same is true for Leah. She was not able to beat the entire thing. And in the way the lawsuits work, you plead everything and then you prove what you can and you win on what's left. And so a lot of those, I think the judge was absolutely right throwing them. And you and I did a video discussing the proposed order several months ago at this point, I think. And really, other than a few nuances, the order didn't really change very much, which means whatever argument was had at the hearing, the judge wasn't terribly convinced either way. And so the judge's ruling is, for the most part, intact.
Right. And there was a whole part of the thing that the judge threw out that he said Leah's team would be able to refile a supplemental affidavit or whatever and possibly get it reinstated. I think that was about her her father and her daughter.
Correct.
If I'm not mistaken. Now, and just so that everyone sees the language of what we're talking about here regarding the attorney's fees, it says a prevailing defendant on a special motion to strike shall be entitled to recover its attorney's fees and costs. Of course, in some instances, the reverse is true. Given the mixed nature of this ruling, any party may file a notice motion for attorney's fees and costs if they elect to do so. The court makes no finding at this time whether there actually is such a right to attorney's fees and costs by any party. The right to attorney's fees and costs and the amount thereof will be determined at any hearing on a notice motion. Be that as it may, any party who files such a motion should keep in mind the standards for such a request. So what is the standard for such a request?
So, I'm not completely clear on that because I'm again, not super up to speed on California law, but it's the language right there, that last sentence that I find fascinating. The lawyer brain in me peaked and I had like warm fuzzies when I read that sentence. That is a quiet threat from the judge. If you file this and you don't win, the other side will pay the other side for the inconvenience of, right? So the fee shifting says I have to file a motion. I have to prove I'm entitled to fee shift. And if I'm not entitled to fee shift, the other side is entitled to fee shift because they spent all this money defending something that they shouldn't have had to defend. And the purpose of these fee shifting provisions is to eliminate all this just extra crap that gets filed and all the extra time and all the extra resources it takes to hear this essential nonsense. And so the judge says, if you file it, you better be right. But what I'm not telling you is you're probably not going to be.
Right. I think one of the biggest developments in this hearing, or one of the biggest things one of the biggest takeaways from this final ruling here, is that RTC, the organization David Miscavige is the head of, is still a party in the lawsuit. And that was probably the main thing Scientology was hoping to accomplish, was getting RTC removed.
Correct.
And I'm just blanking out right now on whether David Miscavige is personally named in this lawsuit or whether it's just RTC.
He is named because remember, the judge entered an order effectively deeming him served. And if he didn't accept service, he was going to order him served. And so Miscavige signed the waiver.
That's right. That was in Leah's suit. I'm getting Leah's suit and I'm getting the Jane Doe suit confused. You're right. That did occur in Leah's suit. So as of right now, it seems like David Miscavige, we are still on the trajectory of seeing him deposed. Is that your take on this?
It is. And the good news is my youngest has outgrown their high chair. So I'm going to go ahead and ship it out there for David Miscavige to sit in for his deposition. So that way he can see above the table.
Praise Xenu. That's very generous of you. So I feel like it's almost like an act of desperation. This quote, let me pull up the quote again from Scientology's faceless spokesperson, Corinne Powell. A resounding victory for Scientology and free speech. That to me now seems like it reeks of desperation, of that she's probably going to be scrubbing dumpsters with a toothbrush for the fact that David Miscavige was not dismissed from this lawsuit.
Well, that or she discovered a thesaurus under a desk somewhere and went, let's try these new words. It's a joke I tell my college students all the time. Don't use words if you don't know what they mean. Just because it fits in a sentence doesn't mean you should use it.
A resounding victory that some paragraphs were removed from Leah Remini's complaints. It's truly incredible.
It's a resounding victory. The judge did his job. Who'd have thunk it?
I did hear from another attorney today who said that in their opinion, some of the items that were removed by the judge here were the items that would have had the most teeth or the most in terms of damages. A couple of the items of tortious interference were removed. I think 2 of the 4, if I'm not mistaken. And a lot of the a lot of the hateful rhetoric that I think has been argued has cost her economic opportunity. Do you have any thoughts on that?
I agree with that. I think those were going to be a little harder to prove up as fact. And because, and I don't know if it's on purpose or if it's just by sheer dumb luck and, even a broken clock's right twice a day sort of theory. And you mentioned it yesterday. They are so outrageous that they're almost satirical. And I think the judge really had no choice. I mean, there's a famous case on this. Jerry Falwell versus Hustler magazine is actually the case that sets the standard for this, where a parody magazine, it was basically the Saturday Night Live of publications, implies that the former church leader Jerry Falwell lost his virginity to his mother drunk in an outhouse. That's clearly a parody, but he sued the magazine and Larry Flynt for defamation, and the court said no person can take this seriously. This is so outrageous and extreme. No reasonable person would believe a word in this. And I think that's sort of what happened here.
To me, that's one of the most memorable parts of the movie that was made about the People versus Larry Flynt, right? That's what the People versus Larry Flynt?
I think that's right. That sounds at least close.
And when the attorney, I think put, and I mean, I'm going to take some liberty with this, put Jerry Falwell on the stand and said, isn't it at least conceivable that this could have occurred?
Yeah.
Isn't it at least conceivable that you could have lost your virginity to your mother in an outhouse? He's like, of course not. But couldn't someone believe couldn't someone actually believe that though? He's like, no, nobody could ever believe that. No reason could ever believe that. And based on that grounds, it was thrown out that if no reasonable person could ever believe it, then it's not slander or it's not libel or whatever.
Right. And I think, I think it's interesting too, in defamation law and slander law, which is at the heart of this lawsuit. 50 years ago, it was a lot harder. Like, you could get away with something that people might be more reasonably inclined to believe. The statement, Leah is a Nazi and, prays at the altar of Hitler, which is clearly wrong. You would think in today's day and age, there would be photo proof to support it. And I think it's different if they're either manufacturing or doctoring photos to create some substance to these allegations. But if they're just allegations alone, I think the judge, as much as I don't want it to be right, I think the judge was right.
Awesome. All right, cool. Well, I know there was a lot of misunderstanding about what the status of this lawsuit was. And it's weird. That's why I was so confused when you and I were chatting just before we started here. I was like, how can a publication called Courthouse News Service contribute to such a misleading headline, knowing that most people don't read headlines? And I don't know. Are you familiar with this publication?
I'm doing a quick Google search, and I'm rapidly becoming familiar with it. That's
okay. I was just just wondering if it had a reputation or anything, because it just seems so silly,
So it appears to be relatively well respected. I'll be honest, as a lawyer, I've never heard of it, but that doesn't necessarily mean anything, because I tend to get my legal news from other sources. Like direct from the courthouse, or as a lawyer in the jurisdictions in which I'm admitted, there's often newsletters or, CLEs or continuing legal education and things where I get this information through different sources. So I can't independently speak to the publication.
Yeah. Okay, cool. All right. Well, before I ask you if you have any other thoughts about this that you wanted to share, I just wanted to remind any newcomers, if you're not already subscribed to Zach's channel on YouTube, you can find him at Your Lawyer Friend Zach. Oh, by the way, I should tell everyone, the L. Ron Hubbard birthday event is the live event with David Miscavige is actually happening as we speak right this moment at Ruth Eckerd Hall in Clearwater, Florida. I don't know where I got the idea that it was actually happening on Saturday. No, it's happening right now, folks. Right now. So we will not be live streaming. I will not be live streaming as Danny Masterson outside Ruth Eckerd Hall on Saturday. Probably, thankfully, because I think it's going to be like 80 degrees. So marked safe from having to stand outside in a wig in 80-degree weather. But unfortunately, we did miss. I mean, I wouldn't have been out there tonight anyway, but I just wanted to let everybody know that. Was there anything else about this lawsuit worth discussing that we haven't touched on?
No, but
right
I
now?
did. No, but I did the Courthouse News Service. I did just learn. So they are a competitor. Thomson Reuters, who owns Westlaw, Lexis, who owns LexisNexis, and Bloomberg. Those are the three big legal databases. Allegedly, they're a competitor. They have a grand total of 2,200 subscribers, according to what I've seen. So apparently, their viewership is, I know personally 2,500 lawyers just by myself probably who have access to Lexis and Westlaw products who have probably never heard of this. So I don't know that we're necessarily, my opinion, we're not necessarily dealing with top tier journalism here.
Wow. Well, good to know. All right, everyone. Just a brief one this evening. Thank you all for hanging out with us. Thank you, as always, to everyone who watches until the very end, and we'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe